Hi, I'm Palmer Johnson. Welcome to my video series where I answer frequently asked questions I get from clients about um, legal matters related to adult guardianships and probate and estate planning matters. And today I'm just going to talk generally about something that I have seen, um, which is this idea that an adult guardianship is not a tool to rewrite a will. Um, that you don't like. I have seen this in several instances where um, a, a child is maybe been written out of or disinherited and they're aware of it, and then as their adult elderly parent becomes closer and closer to death and is having some health issues and may have in fact some capacity issues at that point, um, this person, they sort of come in under the guise that this person is incapacitated and that they should be appointed their guardian to protect their assets, when in fact, upon further investigation, you find out, um, regardless of whether the adult is currently incapacitated, that this person should not be the person that's the guardian. And the reason why I would really warn anybody who is considering trying to do something like this is that there can be really specific criminal consequences for these types of actions where you are seeking to take advantage of an incapacitated or elderly adult, and you can absolutely be prosecuted for that. The city of Tulsa has a whole crimes unit that is absolutely devoted to investigating these types of crimes. So, unfortunately, if you've been validly disinherited years ago, um, you're not going to be able to come in and obtain guardianship at the end of your parent's life and somehow undo or change their estate plan. It's also not a tool to hire an attorney to come in and write a new will for them while you're questioning their capacity. Also, it would be questionable whether or not the the adult, if you are the person who hired and paid for the attorney to come in and do something in your favor, that there's not a clear conflict there. So I guess the takeaways here would be for people who are doing estate planning, it's important to do this um, and make your intentions known, execute the proper documents um, well in advance of any kind of sickness or infirmary, so you're not vulnerable to this potentially from a family member specifically that you've disinherited. And for anybody who thinks that this may be a way that they can um, sort of get back something that they think they've lost, that would be, potentially very unadvisable thing to do. So, but these types of cases are very fact specific, and um, uh, the issue of capacity can really be debated, and it again is very fact specific. So if you find yourself in either scenario, I think I would highly recommend that you talk to an attorney about what what you should do next, and what options are available to you, and what the facts of the specific case are. So if you've got questions or would like to discuss your personal case, I can be reached at Worth Law Office, and I'd be happy to set up a consultation with you to talk about the ins and outs of either obtaining guardianship over an incapacitated adult, or as part of a larger estate plan, what you would want done and how best to address your care in the event of your incapacity.